Good morning, everyone. Thank you for this opportunity. My name is Yohanes Hermanto Sirait. Today, I will present you our research urgency in using Indonesian language on business contract and potency of investment dispute, the study of Supreme Court Decision number 601K/PDT/2015. In this presentation, we will share you introduction, methods, research and discussion, and lastly, conclusion. For the introduction, we all believe, then we all agree, that the function of national language is not only as official language, but also as unifying language. This recognition comes into binding when Law Number 24 of 2009 on national flag, language emblem, and national anthem issued. In Article 31, stated that Indonesian language shall be used in any memorandum of understanding or agreement which involves state institutions, government institutions, private institutions, and individuals of Indonesian citizens. We all believe the objective of this article is to ensure the protection to both parties in any agreement that made in Indonesia. That is a noble objective to protect, not to attack. As a sovereign state, in international law, Indonesia may obligate the use of official language in any agreement that made in Indonesia. That is normal in the context of international law. But we also need to know that the issue occurs when the development of business requires the use of a varied language, especially English. In some cases, there is something called a standard agreement, which is drafted in English. Most of business actors, especially who come from different countries, use English as international language for contract. But in this research, we found that there is a legal dispute between PT Bangun Karya Pratama Lestari versus 9AM Ltd. This case became interesting because PT Bangun Karya Pratama Lestari, domicile in Jakarta, as plaintiff against 9AM Ltd, domicile in Texas, as a defendant. This case concerned a legal relationship between both parties on a loan agreement in April 2010. Both parties agree about a loan of some money between both parties. The clause of the agreement stated that the agreement subject to any private law in Indonesia, but the problem occurred when the facts show that the agreement only made in English version, so there is no Indonesian version. But there is something that I hardly understand. Why PT Bangun Karya Pratama Lestari choose to sue 9AM Ltd, then ask 9AM Ltd to make Indonesian version of this agreement. I think if it is a good fit, then both parties can make Indonesian version of this agreement and there won't be any legal dispute between both parties. Supreme Court Decision number 601K/PDT/2015 has rejected the appeal from defendant 9AM Ltd and state that the previous court decision judice facti was correct. It means that there is no mistake in applying the law. The Supreme Court believed that the lawsuit is based on applicable law. It means that the Supreme Court Decision number 601K/PDT/2015 is final and binding. That means the agreement between PT Bangun Karya Pratama and 9AM Ltd is null and void. The court cancel the agreement between both parties. Okay, for the method that we use in this research is normative research using a statute and case approach. The data is primary, secondary, and tertiary legal material. This article will analyze all legal material deductively. The main issue of this article is to understand whether the Supreme Court decision exact or not, whether the Supreme Court decision will support the investment in Indonesia or not. Okay, from the research, we discuss about the impact of the Supreme Court to the investment in Indonesia. First, we found that investors now, or after the Supreme Court decision made, the investor must understand that the using of Indonesian language in any contract made in Indonesia is not solely formality, but the using of Indonesian language is substantially because it will affect all part of the agreement. The contract with an Indonesian version is null and void. This case, so does fact. The decision become role of model for other agreement in Indonesia. We are afraid that any other agreement that had not been made in Indonesia version that sue before the court will be decided as null and void, similar to this case. To make sure that our criticize to the Supreme Court decision is right, we make some comparative law by seeing or by examine the best practice in the cancellation of agreement. In many states, including Indonesia, the cancellation of the agreement always based on whether the agreement against private law. For example, in Indonesia, we cannot make a sale agreement on human because it will be against the human trafficking law in Indonesia. Or secondly, whether the agreement against public morality, which is involved with religion, custom, or any morality that prevail in Indonesia. So when the Supreme Court cancelled the agreement, it is new in Indonesia. For an agreement is null and void because it was not written in Indonesian language, especially when we have an option to make Indonesian version. If the problem is only formality, then we can repair the formality by make Indonesian version. If the problem is substantially, and then it will be another problem, not the problem that we discuss in this research. In the conclusion, we conclude that the mandatory to use national language or Indonesian language is formal requirement, not substantial requirement. It means that something formal should not affect the substantial of an agreement. We disagree with Supreme Court decisions that cancel the agreement because the agreements have not been made in Indonesian version. The Supreme Court's decision will affect investment because the investor will think back whether they should invest in Indonesia or not, especially when they don't really understand Indonesian language. We also criticize the Supreme Court because they didn't see any other fact about this case, that between the plaintiff and the defendant there had been any other agreement that had not been made in Indonesian version, and there is no any problem until this case occur. So we suggest to the Supreme Court that it is better if the court delay the agreement until Indonesian version made by both parties, then cancel all the agreements because it is not made in Indonesian version.